Alrighty, so this morning's workshop is the first in a series of 6 workshops that will be held on Monday mornings at 10 o'clock for an hour. And these workshops are funded through the Australian Government Department of Employment Workplace Relations through their Productivity Education and Training Fund grant program. So the idea of this is that they're funding employer bodies so that we can help keep employers up to date on the raft of legislation changes that have happened over the last few years. This morning is really an overview of the changes that have occurred since around 2022. So some of this you might already be aware of, some of it you might not, and we'll also give an overview of the most recent Closing the Loopholes changes. Please bear in mind that we will have separate workshops on things like casual conversion, wage and super theft, employee versus contractor. So if you're looking for some more in-depth information on some of those, have a little look on our training calendar and you'll see that we've got a series of free workshops covering those areas as well. So without further ado, this morning we're going to cover off paid family and domestic violence leave. Everybody should have already implemented this, so this is really just a little reminder. We'll also cover off some of the changes or the key changes of the Secure Jobs Better Pay Bill, the Closing the Loopholes changes, and very quickly touch on positive duty requirements for the prevention of sex-based discrimination and harassment in the workplace.
Actually, I'm not sure if you're aware, but Kelly's husband's doing the run from Copper Creek to
Alrighty. So if you missed the beginning, we will have an opportunity for questions at the end. We are recording this session, so it will be available on our website as well afterwards. This workshop comes with a disclaimer that this information is general in nature, and we do recommend that you seek specific advice for your circumstances. So it's really an awareness session. So as of the 1st of August 2023, paid family and domestic violence leave applies to all businesses regardless of size, and it entitles employees 10 days of paid leave in a 12-month period. Employees don't have to be permanent to access this, and they don't have to work a set period of time in order to accrue this leave. It's an automatic entitlement of anybody when they commence employment. It doesn't accumulate, and it's 10 days over a 12-month period and replaces the previous 5-day provision. So this is paid leave that businesses will be paying for. And there are rules in place about information that should not be included on a pay slip. So if you're not familiar with those rules, there is a lot of information available on the Fair Work website, but also we can give you some advice around that as well. So really, from a business perspective, the Fair Work Ombudsman has created quite a useful employer checklist to make sure that everybody has taken appropriate steps to prepare and has a plan to respond in the event that you have an employee that requires to access this leave. I'll send a link to that around after this session. So we'll send you a few resources following this session that link to some of the things that we've talked about. Employers should be publicising this entitlement so that affected employees are aware of it and know how to access it. As you would appreciate, if somebody's requiring this kind of leave, it can be quite a sensitive issue. So if you do have a larger organisation, I suggest that you have multiple contact points that people can initiate accessing this type of leave. Consider having a policy and a procedure to ensure everyone is aware and knows what the process is to access this, and that includes what sort of evidence and notice requirements are required. So that's paid family and domestic violence leave. So as I said, we're jumping back a few years. This was really an opportunity just to cover off the key changes that have impacted employers over the last few years to make sure that we didn't miss any of them. The Secure Jobs Better Pay Bill was really around increasing job security and addressing gender equality in workplaces. One of the things that was introduced as part of that is the prohibition of pay secrecy. So that's actually quite important. If you have employment contracts that have references to people not sharing the details of their remuneration, you need to reissue those contracts without those clauses in them, and any new employment contracts that are issued should not have a requirement around employees not sharing what their pay or salary is. We've also had the sunsetting of zombie agreements. So they're agreements that were entered into pre-2009. So if you're operating on a very old enterprise agreement, it's probably not valid anymore and probably time to start thinking about renegotiating a new agreement. The Fair Work Ombudsman or the Fair Work Commission also has the powers to correct errors in enterprise agreements. And there's been some changes to how bargaining can be started through the Fair Work Commission, which is around multi-enterprise bargaining, and that they can actually make an approach to you to commence a bargaining process. There have been some changes to requests for flexible working arrangements, with particular employees having greater access to flexible working arrangements, as well as the reasons why flexible working arrangements might be refused. Those reasons have become a lot narrower, and the business case to refuse requests for flexible working arrangements needs to be a bit more robust than it might have been in the past, as well as changes to fixed term contracts. Unless you are employing people for a parental leave cover or a fixed period of time, or employing somebody for a fixed project or term of funding, we're sort of leaning towards avoiding using fixed term contracts. If you're worried about funding running out and those sorts of things, there are other ways to get around that. But there's also some really useful information on the Fair Work website, particularly in the fixed term contract information statement, which is just as useful for you as an employer to refer to as it is for people working under fixed term contracts. So realistically, these are the things that you should have done or should be thinking about doing, is removing those pay secrecy clauses from employment contracts. If you have an enterprise agreement from before 2010, it is likely that it is no longer valid. Ensuring that our pay rates and employment conditions in job ads are compliant with Fair Work requirements. You can get a slap on the wrist if you're advertising things like piece rates in job ads, not legal. Review or implement processes for managing requests for flexible working arrangements, so that there is a clear process that people can request, and also clear criteria and business case for refusing any requests for flexible work. As well as reviewing the use of fixed term contracts to ensure they're compliant with Fair Work requirements, and that if you are using fixed term contracts, you are providing the fixed term contract information statement to every employee on a fixed term contract. If you are government funded, particularly in the community services space, you probably meet the requirement for an exemption where you can demonstrate that a role is linked to a funded program or service, a government funded program or service, then that's actually a valid exemption from these requirements. But if you're using fixed term contracts because you want to get out of jail free card for terminating employees that aren't working well, I would suggest that you might need to review that process because it's probably not compliant with the requirements. Reiterating the fact that this advice is general in nature. So they're the older changes. The newer ones, which we've been running a few information sessions on over the last sort of 12 months, but we'll reiterate here just in case you haven't been to those sessions. We're going to look at the right to disconnect, which is now embedded in all modern awards. We'll have a very an overview of the new definitions in terms of types of employment, which has an impact on casual employees as well as the use of independent contractors within organisations. We'll also have a look at new wage compliance requirements, delegates and union powers, protections for employee-like workers, and changes to enterprise bargaining. So the right to disconnect was something that was quite heavily publicised, but like many media and social media situations, was not entirely accurate. It is a right for employees to ignore out-of-hours contact under certain circumstances. So the new right allows an employee outside of their working hours to refuse to monitor, read and respond to contacts or attempted contact from their employer. And it also extends to third parties such as clients or customers. The right to refuse cannot be exercised if that refusal is unreasonable. So if you're calling people in for work or it's a time-sensitive requirement, then there is still an expectation that employees would respond to those out-of-hours contacts. However, the other consideration is what is that person being paid? So if you have employees that are on, generous salaries that factor in, a reasonable amount of overtime, that may be exempt from the right to disconnect within reason. It's just, I think the most important thing with this change is that we are talking to people and we understand what our workplace culture looks like in terms of out of hours contact. If there is an expectation that your employees would be available out of hours, then having a conversation with them about what's reasonable and putting some parameters around it. So, if you've got people that are in management roles that need to have contact from staff members early in the morning to say that they're sick and then you need to replace them, putting some guidelines around that. So if you need to call in sick to your manager, you need to call in sick after 7 a.m. in the morning, so they're not getting a phone call or a text message at 5 o'clock in the morning or 2 o'clock in the morning or whatever it might be. And depending on the size of your business, you might want to consider reviewing employment contracts to actually specify what sort of out of hours contact is required. Or putting in place a process if people are being contacted out of hours and they feel like it's unreasonable and unnecessary, then what should they do about it? So where would I raise that issue if I keep getting phone calls from a client or from another staff member or from a manager and I'm trying to enjoy some home time? How do I raise that as an issue so that it can be addressed? So you can send an email or a text message to an employee outside of working hours. You can call an employee outside of working hours, provided that the reason for the call is a reasonable reason. If you're ringing up to have a whinge about the day or to, debrief, and it's not a time sensitive thing, then it may be considered unreasonable contact. And it's not a criminal offence to contact employees outside of work hours. The right to disconnect doesn't prevent you or a third party calling an employee, texting them or emailing them outside of working hours. It is the right for them to choose to ignore that if they so wish to. One of the things that is important to consider with this is that if an employee does exercise that right, they can't be treated less fairly as a result of exercising that right, because that is a workplace right, which means that if you did treat them less fairly because they choose to exercise the right to disconnect, you may be liable for a general protections claim, and that's where an employee is treated less fairly for exercising workplace right. So it's important that we have a process to manage this so that everybody's aware of what this is, what it isn't, and what we can and can't do in terms of contacting employees outside of hours. It applies to all employees covered by the Fair Work system, so pretty much anybody that's earning under around $175,000 a year. It very much applies to employees that are on an hourly rate. So if they're on an award hourly rate for time worked, the out of hours contact should be limited to only that urgent and as necessary. And as I said, the right operates for the purpose of adverse actions or general protections provisions, so employees are able to exercise this right without any disadvantage. If you find yourself at loggerheads in terms of you believe that contact is reasonable but the employee does not, the Fair Work Commission will mediate a discussion to determine who they think is in the right. So you can, if you wanted to, take it to the Fair Work Commission. However, I would suggest it would be a much easier process to address it at a workplace level. So what you can do, consider the forms of outside of working hours contact that you're currently using. If you are a policy-based organisation, strongly recommend having a right to disconnect policy. Review and potentially amend employment contracts if you think there is a grey space in terms of, that out of hours contact and you want to put some parameters around it. You can certainly look at including that in an employment contract, and it would be a clause around, you're compensated for out of hours contact, potentially for these reasons or between these hours, depending on the context of your organisation and your industry. Educate managers on this right so that they understand it, and encourage managers to respect employees' privacy and avoid that unnecessary contact out of work hours. and implement a procedure, even if it's something relatively informal. Like if you feel like this is too much, let me know and we'll have a talk about it. It's really just making sure that we've got a process that employees can follow if they would like to exercise this right or get some clarity around what is and is not reasonable. So the next part of the Closing the Loopholes bill is the casual employee definition. This is a bit of a minefield. They've changed the definition of casual. So the employment relationship, the person would be considered to be casual if the employment relationship is characterised by the absence of a firm advance commitment to continuing and indefinite work. So that is that there isn't a reasonable expectation of ongoing work. And the employee is entitled under an award or enterprise agreement to be paid a casual loading or a specific rate of pay as a casual employee. So in determining whether or not there is a firm advance commitment, the consideration is really around the real substance, practical reality and the true nature of the employment relationship. So effectively, you can have a great casual employee contract or agreement that says we only employ you for the start of the shift to the end of the shift, which is the true definition of casual. And at the end of each shift, your employment terminates and commences again at the start of your next shift. If you put somebody on as a casual and they're working Monday, Tuesday, Thursday, ongoing, and Fair Work reviewed that, I would suggest that you would find yourself in a bit of a spot of bother because it certainly appears that there's a firm advance commitment. However, if that is just for a season, so if you're in agriculture or hospitality or a seasonal type industry, and you can demonstrate that you're only employing that person to manage the peaks in demand for your business, then you're in a much better position to argue that that position is in fact casual. There are so many grey areas in this space. We could spend a whole day asking questions about different circumstances. I think if you're in doubt and you're not sure, it's a good idea to seek some advice. So the firm advance commitment is where we would look at whether there is an inability of the employer to elect to offer work or an inability of the employee to elect or accept or reject work, and whether this happens in practice. So one of the benefits of being a casual employee from an employee perspective is that you can refuse a shift. I don't want to work that day, thank you very much. Whereas if you're a permanent employee, generally you don't actually have a say in whether or not you're going to work. You will work as per your roster. And if you don't want to come to work, then you'd be asking for a day off or perhaps somebody's sick. So we'd be looking at whether or not the employer can choose not to give work and whether the casual employee can choose to refuse that work. And in practice, that's usually, if you've got a not availability book or something like that, where people would indicate when they are and are not available to attend work. The other consideration is looking at the business. Is it likely that there is going to be availability of ongoing work of the kind that that employee normally performs? So, as I said, if you've got seasonality built into your business, then that sort of leans very much in the favour of a casual employment relationship. Whereas if your business is fairly consistent in terms of its turnover and demand, you probably would struggle to meet that aspect of the test. There's also a consideration given to whether or not you have people that are full-time and part-time performing that same kind of work. But there are exceptions to that because we do need to have some flexibility. If we've got full-timers or part-timers that are off on leave or sick, a lot of businesses will need casuals to plug those gaps. So obviously that kind of work would be quite sporadic and not consistent, which would then put a tick in the favour of this is absolutely a casual employment relationship. And they'd be also looking at that regular pattern of work. So this was our get out of jail free card up until the introduction of this legislation. As long as the hours were not regular and systematic, the employee would not be deemed to be casual. So they've kind of got this in here as one of the considerations, but it doesn't have to be absolutely uniform. So it might have fluctuations or variations, but if it's reasonably consistent and ongoing, again, it would be a harder argument to make that that employee is casual. And just to make it super complex and extra grey for everybody, no single consideration listed is determinative, and not all of them necessarily need to be satisfied. So effectively, if you can put a tick next to two of them, you might be in a good position, but depending on the context, it might not be enough to concretely say that this employee is a genuine casual employee. Hopefully you're all aware of the casual employee information statement, so that needs to be provided to all casual employees upon commencement of employment, after 6 months and after 12 months, unless you're a small business, so less than 15 employee headcount. If that's you, you just need to give it to them when they start and after 12 months, and then you don't have to give it to them again. So this is really around the employee choice process. So casuals don't magically turn into permanent employees. And the employee choice process has replaced the casual conversion process. So now you don't have to offer a casual conversion or offer permanent employment after those designated periods. The onus is actually on the employee to make a request to you as the employer to say, I'd like to exercise my employee choice. I don't think that my employment is casual anymore, and I would like to consider permanent employment. Which can be problematic because you might send out the employee, casual employee information statement, but somebody might not elect to request to go permanent for 3 or 6 months after you've issued that statement. And depending on how the employee's employment looks compared to those factors we were looking at just before, you may or may not have grounds to refuse a conversion. Again, if you were going to refuse a request to convert to permanent, I would be looking to seek some advice around how to structure that refusal and making sure that you've actually got a genuine business case to refuse it. Saying it's too hard is not going to be sufficient. You will need to be able to present a business case as to why you don't believe that that employee is in fact entitled to permanency, or why it would be too much of an impost on your business to accommodate that. So you'd need to make significant changes to rostering or the way that you operate your business in order to accommodate that conversion. There are some requirements around that. So the request from the employee needs to be in writing. You need to have a meeting with the employee after receiving that request to discuss what they think they would like. So what that permanent role would look like for them. So, you know, what days, how many hours, those sorts of things. And then you've got 21 days to respond to either accept or decline. And you need to do that in writing. So it's quite the process between making sure that we're issuing that casual employee information statement, as well as managing the employee choice process. There's a bit more of an admin burden. This is unlikely to change given the outcome of the election. I know that there was a commitment from the Liberal Party that if they were elected, they would immediately repeal this legislation, but I think that we'll be working in this space with these kind of regulations for the foreseeable future. And I would also suggest that there's probably going to be another raft of changes coming through within the next 6 to 12 months. So stay tuned. So grounds for declining, as I said, if you as the employer still think that they meet the definition of casual, that's grounds to decline. Or if there are fair and reasonable grounds for declining, and as I said, it's things like substantial changes to the way the organisation operates, significant impacts on the organisation. So that might be cost. So particularly small businesses, if you've got people that are permanent, and you would know this already, and there's a public holiday and you don't trade on a public holiday, you're going to be paying those employees anyway. And I've spoken to a few small businesses where they actually did the maths and it was going to cost them $10,000 more a year for them to convert their casuals to permanent. And that business was quite a small business, and it was a very significant chunk of their profit margin for the year. So they can make that business case that this is actually going to cost us a lot of money and we can't afford to do it. But you would need to have the business case to show what it would cost your organisation in order to make that argument a robust one. So that's the joys of the employee choice or casual, new definitions to casual employees. So I will circulate this presentation afterwards as well. So we've tried to put some tips in here for what you should be doing. Make sure that you're issuing that casual employment statement, and that you issue it at the frequencies that it needs to. So 6 and 12 months if you've got 15 or more headcount, or at that 12-month point if you've got less than 15 headcount, and also that it's issued upon commencement of employment. I would recommend doing this via email because then you have an automatic paper trail that you've sent it. Have a look at your casual contracts, so review casual contracts or letters of offer and update any terms which might indicate a firm advanced commitment to continuing indefinite work. In some ways, offering a casual employee a contract is kind of a commitment to offering firm and indefinite firm advanced commitment. So you might like to consider, letters of offer and just letting people know what award they're being paid under, at what classification and what their pay rates are. Make sure that your onboarding processes are robust enough that only casual employees are employed as casual. So if you are employing somebody for ongoing and continuing work, and the hours will be somewhat regular and systematic, I would be strongly advising that you would bring those people on as permanent employees. If you do like to use casuals as a bit of a trial, lean back into your probationary periods. So businesses with more than 15 or more headcount, you have 6 months minimum employment period before someone can make an unfair dismissal claim. Make that 6 months a really robust 6 months and check in to make sure that that person is actually performing the way you want them to be performing. And if they're not, terminate their employment within the minimum employment period, so that you don't have to go through all of the hoops of dismissing somebody that is a non-performer outside of the minimum employment period. I cannot tell you how many times I've had an employer ring me, tell me that they want to terminate somebody because they're not performing well, and that employee is a week, a month, a couple of months out of their probation period, and they weren't performing for that entire period, and we let it go, and then we went, oh, I've had enough of it now. So put some reminders in your calendars around this time frame so that you can manage that situation within that 6 months. Even better news for you, if you have less than 15 employee headcount, then you have 12 months before to make that decision. Casual employment audit, look at where you're using casuals, put in place a system to manage this uncertainty that comes out of this employee choice. So what are we going to do if people decide they want to go permanent? And have a casual process change. So basically that understanding about how casuals are working in the organisation and where there might be opportunities to convert them to permanent employment if they so wish to. So very important take out of this. If you have casual employees and they want to be casual employees, you don't have to do anything with those people. Just let them be casual and let them do their thing. It is up to the employee to approach you as the employer to request to convert to permanent employment. And if you have casuals that are happily trucking along in your workplace being casual employees, because that 25% loading is quite nice in your pocket if you don't have all of the, mortgage and needing job security situation, then just leave them be. But just make sure you give them the casual employee information statement. All right, so another definition change, which is the definition of employee and employer, and both of these will be determined by reference to, I love these terminology, the real substance, practical reality, and true nature of the relationship between parties. So if you are using independent contractors because you don't want employees, this is what this legislation is targeted at. So think about the purpose of it. The purpose is to stop people starting a business and not having any employees and a whole bunch of independent contractors, because I can get rid of them whenever they want. I don't have to pay workers' comp insurance. I don't have to worry about all of the responsibilities that come with employing people. It's just tightening up those definitions and return of the multi-factor test. So if you're using independent contractors for things like, garden maintenance or social media or payroll, things that are not your core business, they're not really what this is targeted at. It's targeted at organisations that are engaging independent contractors when in actual fact they should be employees. I'm not going to spend too long on this because we will actually have another session on this. If you can't make it to the sessions that are actually scheduled for the next few weeks, if you register for the session, we will send you the recording. And there is actually a really nice checklist around what sort of things you should be looking for to work out whether or not somebody is in fact an employee or an independent contractor. Up until this change in legislation, which was the 26th of August last year, what we really just needed was a great independent contractor agreement and everybody was fine. Now they're actually going to look past that agreement. So yes, you still need a good agreement, but they're going to look at the totality of your relationship. So as the employer, are you dictating when they need to come to work? Are they wearing your uniform? Do they look like an employee of your organisation for all intents and purposes? How much control does that contractor have over the work? Can they subcontract out the work to other people? Do they have their own business brand that is separate to your organisation? All of these are questions that will be looked at in determining whether or not somebody is in fact an employee or a contractor. And they will, if there was a question as to whether or not somebody was a contractor or not, they will be looking at that relationship and how does that relationship look from the outside? Does it look like that person is an employee? Or does it look like they're a contractor? But there's a whole bunch more nuance in that. So again, if you're sitting in a grey area, register for that employee versus contractor website and we'll be able to give you some more detail around that. So if we do have contractors that should have been employee, there will be a back pay requirement from the 27th of February 2024. There are opt-out notices. So if you're using, so a lot of medical centres and big project organisations use independent contractors. If those contractors are on $175,000 or more combined income from all of their clients, they can opt out of that requirement. And the reason for that is it's deemed that somebody that's earning that kind of money is in a position to advocate for themselves. Whereas if and I'm going to use a stereotype here, so apologies in advance, if I'm a single mum with not very many qualifications and I'm returning to the workforce and I want a cleaning job, and that cleaning company saying I have to be an independent contractor, the perception and the reason for the legislation is that people that are working in lower skilled occupations tend to not have the ability to advocate for themselves the way that, a doctor or an engineer or somebody that's earning a bucket load of money would be able to do for themselves. And it's really just letting them know that they can opt out of it, and then they would send you an email to say, yeah, I want to opt out of this thing, so I'm happy with my independent contractor arrangement. So what next? I would be reviewing the use of independent contractors if you haven't already done it. We have an independent contractor assessment tool, but there's also versions of that available online. And then a group for our website, our webinar coming up in a few weeks. Attend the employee versus contractor webinar, or at the very least, register for it, and then you will get a recording. Wage compliance. So wage and super theft is next week's topic for the workshops. So there's a couple of things that have fallen out of that. The first one is the same job, same pay. This only applies to labour hire. So if you're using labour hire employees in your organisation performing the same work as your actual employees and you have an enterprise agreement, then there can be an application made for a regulated labour hire arrangement order. Rolls off the tongue, doesn't it? And that's where the labour hire employees must be paid the same amount as the people that are your actual employees. And that's somebody needs to apply for that order for that to happen, and you'll definitely know about it if it does. Wage compliance. So there is now it is now a criminal act to deliberately underpay employees or not pay their super. So the word that is very important in that is deliberate. So if you know that you are not paying people correctly, I would seriously fix that very fast. Because if there's evidence that you knew you were underpaying, then there is a good chance that you may face criminal charges for that. Also making sure that super is paid at the rate that it needs to be paid and when it needs to be paid. If you've become aware of an underpayment, you can actually self-disclose, and they will work with you to try and calculate the quantum of the underpayment and fix it. It's all about cooperating with the Fair Work Commission in order to get that protection. So there's never been a better time to do a bit of a audit on your hourly rates, making sure that you're capturing all of the allowances, making sure people are classified correctly. But again, we'll go into some more detail about that next week. So double down on your compliance exercises around payroll, undertake regular checks. Businesses are particularly vulnerable if you've got people that have a bit of role mobility, making sure that you're very conscious of the classifications. So once somebody starts performing tasks at a higher classification, they are entitled to the higher rate of pay. And that's brought some very big multinationals undone in recent years. Assess your independent contractor arrangements to make sure they're compliant, and seek professional advice from trusted sources. So one of the things that we have found lately is that people have been getting pay rate advice from people that are not experts on pay rates. If you need advice on tax, on superannuation payments, your accountant is absolutely the way to go, or your bookkeeper. I would be reluctant to take advice around rates of pay from an accounting firm or a bookkeeper without double checking it with either Fair Work, with us, or with your industry association to make sure that advice is correct. And I'm not saying that to badmouth anyone. It's just that we've had a few people, we're like, where did you get this rate of pay from? This is not right. Oh, my bookkeeper gave it to me. Oh, my accountant gave it to me. Oh, I don't know, Joe Blogs down the road gave it to me. So make sure that when you're getting advice on pay rates and penalty rates and allowances, you are going to an industry professional in order to get that information. But I will say that superannuation, I would talk to an accountant about that. We do get a lot of super questions and we can answer the really basic ones. But sometimes there's a level of complexity with that, particularly for your independent contractors. There is a requirement to pay super to them in addition to their invoice amount. You can't package superannuation into an independent contractor payment. It needs to be paid by you on behalf of that independent contractor. And then it gets really grey because if the contractor is a company versus a sole trader. So again, talk to the tax office or your tax agent about that, or jump onto the ATO website because there is some very useful information on there. Delegates and union powers. So the new right of entry exemption certificates for union officials. So where there's a suspected underpayment, union officials can apply to Fair Work and get an exemption so that they can come on site without giving you any notice. And that's really just to make sure that no evidence is, you know, I'm picturing the 80s with people rushing to the shredder with all of the paperwork. But that they have the right to do that, and you need to be nice to them when they come. That's the next dot point there. Obligations on conduct towards right of entry permit holders. So we might not like it, but they will come on site, they will have a list of their members, and they will want access to information around pay rates so that they can gather information on the suspected underpayment. There's also new rights and entitlements for workplace delegates. So these are the elected union delegates within your organisation, and that's things around communication channels. So they need to have access to a laptop and a phone, that they need to have appropriate facilities to do the work of the union delegate, access to reasonable paid time, and a right to represent their, I guess, union interests. And there are greater protections for those workplace delegates as well. And I reckon we might see a bit more of that coming through. So this change is really targeted at the sharing economy, or Uber Eats, all of those sorts of organisations, and it basically allows people working in that gig economy to negotiate some minimum standards, and that's just a list of the things that they can and can't negotiate. But yes, if they want to get together, then they can get themselves some minimum standards, which is probably not a terrible thing, but may put the price of the Uber up a little bit. This one's a pretty big one. If you have unions involved in enterprise agreement negotiations. So if you've been negotiating an enterprise agreement for 9 months and there doesn't appear to be a reasonable prospect of an agreement being reached, then it can be escalated to the Fair Work Commission for arbitration. The downside to this is that the arbitration will only give employees more. They will not take anything away from where you have got to in the negotiations. So it is a very big incentive to try and get these negotiations tied up within that 9-month period. And it could be quite an effective tactic for unions to be potentially stalling negotiations, because if they get it to this arbitration, it's only going to be more of a win for employees. They won't lose anything. So that is the content. So who can help? We can help. We have a funded program if you have less than 19 full-time equivalent employees. We can help you with any of this at no charge. If you're a member, we can help you through your membership. You can also go to the Fair Work Ombudsman. They will also be able to provide you with some assistance. So I'm just going to stop there for a minute. And I'm going to morning.